Great. Welcome, everybody. I'm Belinda McCauley, Executive Director of the Beverly Hills Bar Foundation and the Beverly Hills Bar Association. Thank you for watching today, and thank you to all of our great co-sponsors, our fellow bar associations, for sharing today's program with their members. You will receive your CLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, our members-only community. Please also take a moment to complete the feedback survey that's included in the certificate email. Last month, the Presidential Commission on the Supreme Court of the United States submitted its final report to President Biden, having determined that they met their charge of providing an account of the current debate over the role and operation of the Supreme Court in our constitutional system, and an analysis of the principal arguments in the contemporary public debate for and against Supreme Court reform, including an appraisal of the merits and legality of particular reform proposals. President Biden appointed a bipartisan commission to tackle this enormous undertaking, and we're very grateful to have two of those commissioners here with us today to discuss the report. Caroline Fredrickson is a visiting professor at Georgetown Law, where she's teaching constitutional law, labor law, and legislation. Caroline is a veteran of the Clinton White House and of Capitol Hill, including as a Senate Chief of Staff. She had leadership roles at NARAL and at the ACLU before serving as president of the American Constitution Society for a decade. She is also a successful author and makes frequent media appearances as a legal analyst. Caroline clerked on the Second Circuit after graduating from Yale and Columbia. Michael Ramsey is the Hugh and Hazel Darling Foundation Professor of Law and the Director of the International and Comparative Law Programs at the University of San Diego School of Law. He's a constitutional law expert and focuses especially on the areas of war powers, treaties, and presidential authority. Mike clerked on the Ninth Circuit and then for Supreme Court Justice Antonin Scalia after graduating from Dartmouth and Stanford. He has an extensive CV of legal scholarship and wrote a very well-reviewed book about the US Supreme Court. Structuring the conversation today is Judge James E. Blancarte of the Los Angeles Superior Court. Judge Blancarte was an experienced litigator for decades in state and federal court and served a tenured term as LA City Fire Commissioner before being appointed to the bench in 2018. He's a graduate of Pomona and then UCLA Law, and he's been deeply involved with our local legal community throughout his career. In particular, because I cannot let the opportunity pass to brag about Bar World, I'll note that Judge Blancarte was previously the Beverly Hills Bar Foundation's Vice President of Scholarships and also twice President of the Mexican American Bar Association, one of our co-sponsors today. We are so fortunate to have his wit and wisdom to guide today's discussion. Your Honor, the floor is yours.
Thank you. Thank you so much. Thank you to the panelists. It is a pleasure and an honor to serve as the moderator today for this really important and heady topic. I mean, when you pick up the report and the very first thing that leaps off the page is Presidential Commission on the Supreme Court of the United States. My God, if that doesn't start you off with the best impression, I don't know what will, other than hearing the credentials of the panelists we have here today. This report is comprehensive. It is detailed. It is over 200 pages, and it covers an amazing variety of important topics, but we only have an hour and a half. So hopefully what we're going to do is focus on what I believe the membership most wants to hear from these commissioners. But just so you know what we might be missing, they covered the origins of federal judicial power, the genesis of reform, court politics in the early national period, the post-war period, Brown versus Board of Education, a brief history of the size of the court, arguments in support and opposition to court expansion, and the list goes on and on. But trying to keep to our timetable, why don't we begin with maybe the obvious timeliness of this panel discussion, having coordinated directly with President Biden and the White House and his announcement of appointing someone to replace Justice Breyer. I'm sure the Beverly Hills Bar had a lot to do with the timing. It's more than a coincidence that we're having this panel discussion today. My fear is that we may be missing the announcement. Does anybody know what time the announcement's being made?
Right now.
Right now.
I'm guessing it's about, this would be the time, 3 o'clock in the afternoon.
Well, it really is timely. the report talks about, among other things, the opposition historically to many of the people who were nominated. You tell us that President Woodrow Wilson's nomination of Judge Brandeis generated aggressive opposition regarding anti-Semitism. You tell us that Hoover's nomination of John J. Parker was opposed by civil rights groups and labor organizations. And Lyndon Johnson nominated Thurgood Marshall, a trailblazing civil rights lawyer who also met significant opposition, although he was ultimately seated on the Supreme Court. And then there's obviously the whole issue that happened with Ronald Reagan having nominated Robert Bork. That's a brief history of the opposition that nominees often face. Do you all anticipate, and I'm sure you do, but what kind of opposition do you anticipate President Biden's nominee will have, whoever she may be? If we could start with Caroline.
Well, and Belinda knows this because we have been colleagues in a prior life. I've spent a lot of time working on judicial nominations, and in this world particularly. I was deputy chief of staff to Senator Tom Daschle. And then the Clinton White House, I worked in the legislative affairs office, where one of the areas that I engaged was on judicial nominations, and then was chief of staff to a senator, Maria Cantwell from Washington State, during the Bush administration. And so I've seen this, from a whole variety of perspectives. Supreme Court nominations. And of course, when I was in law school, got to watch the nomination of Justice Thomas and the allegations against him by Anita Hill. I think it's a moment where I hope the whole United States is going to be focused on this process. It's unfortunate that I think we've come to acknowledge that it's no matter who the nominee is, there will be vehement opposition. We already see people lining up to attack the theoretical possibilities. But here's the fact. There's no filibuster for Supreme Court nominees. The filibuster has been eliminated for Supreme Court nominees, for lower court nominees, and for other executive nominees. As a result, and speaking from a long time in the Senate, there are lots of bombs that can be thrown and lots of ways of slowing things down, but ultimately, the process will move forward. And so, there'll be opposition. There'll be, probably a lot of nasty commentary. It'll be unpleasant. It's unfortunate. And I think Mike and I share that sentiment that, things are really not in a good place around judicial nominations. But I don't think there's any question that that the nomination itself will be able to proceed. The question is, again, who President Biden will select. And that process is going to be something where he's going to need to negotiate quite extensively with the Democratic caucus, because we all remember it's a 50-50 Senate plus Kamala Harris.
Michael?
Yeah, I agree with all of that. I think that I'd first like to say that the Presidential Commission on the United States Supreme Court, on which we served, was not invited to consider the nomination process. And so in that weighty report that you have in your hand, it doesn't say anything about the nomination and confirmation process, or at least very little, because that just wasn't part of our charge. And I think at times there was a little bit of frustration on the commission, because I think a lot of us, including me and Caroline, think that the nomination and confirmation process is something that needs to be looked at. But the thing of that is that most of that's really on the Senate side. I understand why the president didn't ask us to look at it, because that's mostly on the Senate side. It's not something that the president really has control over. And whatever could be done on the Senate side to avoid some of the unpleasantness that we've had in the last nominations, not just the very recent ones, but going back a ways, it really has to come out of the Senate and not out of the executive branch. And so as far as this upcoming confirmation, though, I think Caroline's absolutely right that there's going to be some unpleasantness, because that's just sort of the way it's been over the recent times, as the senators have increasingly recognized the significant role the Supreme Court plays. But ultimately, the lesson of recent history is that that if you have the votes, the confirmation is going to go through for the most part. There have been, I think the only confirmation, I may be wrong about this because I'm just speaking off the top of my head here, but the only confirmation that failed where the president and the Senate were the same party was George Bush's nomination of Harriet Miers, which was eventually withdrawn. But in the other cases that at least the recent ones, if you have the votes, you can get it through, even if there's some loud opposition. So my guess is that is with Caroline that's that what you're going to see here.
Can I just add one footnote to that, which is to just say that the commission, well, we weren't charged with looking at the nomination process. There is a bit of a footnote around that in the discussion of term limits. The term limit section, what can you do to sort of a possible reform to the court that many people think would potentially reduce the politicization or the partisanship around the Supreme Court. But there was an acknowledgement that even if you created a system, whether it requires a constitutional amendment or not, for regular appointments by every president that would last 18 years, unless you also deal with the Senate process, it's just not going to work, because there'll be an opportunity just not to take up a nomination if you have the Senate is in the hands of the other party from the president. So in that regard, we kind of got into it and we backed into it in a way so that we could kind of talk about it and mention how broken the system, the process is. But we weren't asked to sort of send in any kind of analysis of that particular part of the whole nominations process.
Well,
Yeah, and if
Michael and Caroline, I realized Michael said, we weren't really asked to focus on the nomination process. What they probably didn't tell you is that my job is to take you each out of your comfort zone. The report speaks for itself, and reading it is an education, all standing alone. I don't want to let two presidential commissioners get away without asking the questions that inquisitive minds want to know. So if we take you outside the rails, roll with it, because we really are interested in having the benefit of the two of you on board this particular webinar. So let me go to the next, elephant in the room. Is this Supreme Court as constituted going to overrule Roe v. Wade? Caroline?
Wow. It's definitely outside. It doesn't really not outside of my comfort zone, I wouldn't say, because I've spoken on this topic many times. In fact, I was the general counsel and legal director for NARAL, Pro-Choice America. So I definitely have a point of view. I helped draft a Democratic alternative to the partial birth abortion bill. So it's an area I've spent a lot of time working in and thinking about. So it's not something I was charged with as a member of the commission. And if I could just say, before we get into that, that we were a group of commissioners from many different perspectives, ideologically, jurisprudentially, legal philosophy, politically, et cetera. But it was an incredibly collegial environment and very and very productive, I thought, in terms of the conversations we had. I learned a tremendous amount. You've touched on some of the subjects that we covered. In our particular area that Mike and I worked on was definitely an intellectual challenge, one of the most complicated areas of the law, jurisdictional questions around the court. That all being said, in terms of where this court is going to go, that was a subtext of the sort of the whatever tension there was on the commission. Was the subtext was the very real possibility, looking more like a probability now, that the court was going to overrule Roe or chop it back in a very, very significant way, so that in all intents and purposes, it was left to die on its own. And so that plus erosions in voting rights, protections, undermining of the Voting Rights Act, and a whole variety of other things caused a number of people, and I would put myself in them, to feel that we are at a very critical stage for the Supreme Court. I do think it would be bizarre if the Supreme Court had set up these questions around Roe and that they didn't actually do something dramatic. I hope they don't. But it would be strange to me, it would be unlikely, I think, that we are not going to see a major change from the Supreme Court in the area of reproductive rights when they decide these cases.
Michael?
Well, Supreme Court's very hard to predict. And so usually you can predict it best by figuring out what I think it's going to do and then figure it's going to do the opposite. I answered this question before in the talk at the Orange County Bar Association, where I was asked this question. And so here was the answer I gave then, and I don't think I've really changed it. I think that what it's going to be is it's not going to be an overruling, because I think there are enough justices on the anti-Roe side who are sort of nervous about straight up overrulings that they're going to avoid a straight up overruling. But I think it's going to be a very substantial cutback along the lines of what Caroline said. I don't think they would have taken this case and posed the kinds of questions they did unless they were going to do something significant. But I don't think they're going to they're actually not going to use the word overrule. That's my prediction. But I think that the state is going to prevail.
Well, in all fairness to your earlier comment about what you did or did not address in the final report, let me take you back into the four corners of the report and ask you, what do you believe or what do you see was the commission's most important charge from President Biden in preparing this report?
Well, it's a great question. And I'll speak to this coming from the progressive side of the spectrum, that there were, because of some of the issues we've just talked about, voting rights and reproductive rights, and a very strong belief that the Supreme Court has become overly powerful and has been moving the law in a direction that is not consistent with where many people think it should be and with where the American public is. That we have, kind of a classic counter-majoritarian difficulty situation. And so, I think the president was presented with a number of, with demands in some sense by activists to address the Supreme Court, and in particular to expand the court. And so what I think the president did, and I think wisely, was to understand that these are really complicated questions. And for those of us who maybe thought there was an answer that was sort of, an obvious political one that you could move forward, once you start getting into the issues, you realize how incredibly difficult they are to resolve, or you start thinking about the unintended consequences that might come from a particular reform. And so I think the president wanted to make sure that whatever ended up happening or whatever direction people would go, there was a very informed conversation with people coming from different perspectives, because people like Mike and I don't necessarily agree on a lot of things. Well, we probably agree on more than we disagree, but that there are certain areas under consideration by the commission where we might not agree. But to hear Mike's perspective in those conversations and hear the perspectives of other people is really important to informing the discussion, so that when we put out a report, people would take it really seriously, because it's not a kind of bomb. It's not something that was thrown into a political debate to blow things up, or to it's really, as you notice, it's not a doorstopper exactly, but it's it's not talking points either. It's not a 2-pager. As I might have delivered to one of my bosses when I worked on the Hill. It's definitely very meaty and involved. So I think that was the charge, and I think we pulled it off quite well. And hopefully, as people move forward and there are these debates that will continue, they will use it as a resource.
So for us mere mortals, what was the charge that you just spoke to?
Well, it is to basically examine the possible reforms to the Supreme Court and provide analysis of what what they would accomplish and what would be the, you know, as I said, the positives and the negatives, the things that might turn out well and the things that might not be expected that might not. And so it was essentially that, and not to provide recommendations, which was sort of the hard part for us to make sure none of it sounded like we were saying, President Biden, this is the one you got to do.
So Michael, from your experience on the commission, what was the most important reform that the commission had to address?
Well, I'm not sure I could pick a single one. I think there were several big ones that were on the table. And I like to start off by saying, somewhat in response to your immediately previous question, what I thought was most significant about the way the commission was set up is that what we were preparing was not an ideological or political document. The commission was bipartisan. It absolutely was bipartisan. And it was bipartisan in actual functioning, as well as in name, in the sense that people who did not share the president's perspective or the more progressive perspective on the Supreme Court were really listened to, and were really a full part of the commission. We did not have sort of a group that a majority group that was running over everyone and just doing what they wanted. It was a back and forth. It was a give and take, and so really was an actual functioning of bipartisan commission. So that was a great thing about it. And the second thing about it was that it was a practical commission, and I think the president is a practical man, and he appointed practical co-chairs to lead us, and we had a practical direction with our document, in the sense that what we were looking at, we weren't looking at the big picture. And when you look at that document, you see it's not a big picture document. It gets into details, but that was what I thought was one of the most important parts of the commission, is that we looked to see how the proposals would actually work and what you'd have to do to implement them. So it's not just some rhetoric about how we need to fix the court, and here are a few thoughts about ways you could do it, but that it is actually a roadmap to what you'd have to do to implement reforms, and what the limitations of those would be. So to answer the question then that you posed directly to me, I actually think that the most important part of the commission's report is the part about term limits. Now, the commission has got a lot of press for the question of court expansion, and we have a good section on court expansion, and I don't mean to knock it, but I think court expansion has always sort of inherently been a political issue. And so you're necessarily going to be, I mean, not necessarily, but I think you're likely to be, if you like what the Supreme Court's doing and you don't share the president's politics, whoever the president happens to be at the moment, then you're not going to be in favor of expansion. If you share the president's politics and you don't like the Supreme Court, then you'll think expansion. You likely think expansion's a good idea. So it's sort of hard to get beyond that. But term limits, to me, is sort of an issue that a proposal that potentially has some real bipartisan traction. It doesn't have an obvious political valence, either over time or in any particular time. So it's the kind of thing that you might be able to get people across the board behind. And indeed, there have been proposals for term limits to the Supreme Court. Usually an 18-year term is what's proposed, by people all across the ideological spectrum. So we took that suggestion and we looked very closely at how exactly that would get implemented. And the report has quite a detailed discussion of how it would be implemented. And you can draw your own conclusions from reading it as to whether it would work or not. It does identify some significant issues that are involved in the implementation, one of which Caroline already referred to, which is the having to do something about fixing the nomination process to make it work. But what was extremely interesting to me was that I came into it with the idea that term limits were probably a reasonably good idea. It's a big picture that they've got a lot of talking points in favor of them. And once that we started delving into the how question, of how they would be implemented, I started thinking they're not such a good idea. And I came away thinking that it was a much more problematic proposal than I had thought going in. And several other commissioners expressed the same view. And I think that's the big thing that we did, was we looked at how specifically these proposals would get implemented and what the upsides and downsides of them were.
Well, Michael, I thought you were about to segue me into asking Caroline her thoughts about expanding the court, but then you brought up term limits. So before I turn to Caroline, let me ask you, in the discussion among the commissioners about term limits, did the concept of a mandatory retirement age ever come up?
There was some discussion of that, but relatively little, and you'll see that there's relatively little of that in the report as well. I'm not entirely sure why that wasn't emphasized more than it was. I think perhaps that we were charged, going back to our charge, we were charged with taking up and analyzing the principal reforms that had been proposed sort of in discussion of the Supreme Court generally. We weren't charged with sort of inventing our own reforms. And I think for whatever reason that mandatory retirement hasn't been sort of at the forefront of the proposals for Supreme Court reform, perhaps because we're a little, we Americans are perhaps a little nervous about the idea of age discrimination. And, you know, the older I get, the more that sort of has some traction with me. I think that there's something sort of uncomfortable, even though I realize that quite a number of state judges have mandatory retirement. And if you look internationally, it's very common in other judicial systems to have mandatory retirement. And so it is sort of a substitute for term limits, which might actually it'd be a little easier to implement.
Well,
But
as a senior, I can tell you that I believe that youth is wasted on the young, and wisdom comes with age and experience. But Caroline, let me ask you, with all that you've learned about the Supreme Court, with all that you knew before being on the commission and everything that you've done in your life, what is your thought on expanding the number of justices on the Supreme Court?
Well, you know, it's a really interesting question. I am, you know, obviously, you know, I come from the progressive wing of the spectrum, but you know, I think of myself in many ways as a small c conservative, that kind of radical changes are something I don't necessarily embrace. I have to say though, you know, so I came in with a fair amount of skepticism about court expansion, whereas I was much more positive, as Mike was, about term limits. I came to believe, actually, and wrote a piece for the New York Daily News after the commission ended, when our muzzles were off, that actually I came to support court expansion because, you know, as I mentioned earlier, the reason why President Biden put this commission together initially was because of the outcry from many people in the kind of progressive sphere about where the Supreme Court was going. I still think term limits are a good idea. I agree with Mike that they're complicated. I think the problems could probably be figured out. It might take a really long time. And it's sort of a long-term good government thing that maybe we should have done at the front end. It would be a lot easier to have it done than doing it now and figuring out whether you need to have a constitutional amendment or whether you can do it by statute, and how do you fix the nomination process, and how does it really eliminate the partisanship of the selection process? Does it basically bring the temperature down, which is, I think, the common phrase that people use about it, because if every president gets a couple nominations, regularizes the process, it makes it therefore less political. And you know, other people say, in fact, it becomes an issue in every election then. So I tend to believe it would bring the temperature down, but I obviously can't prove that. I've spent a lot of time in politics, and I do think something like that would be having a vacancy in a generation, I think creates a much bigger kind of political hullabaloo than having every couple of years. I think Americans would start to just see it as a kind of part and parcel of the presidency. Now, that all being said, I don't think that it addresses the problem that caused the commission ultimately to be created. And that is this basic problem that that at least some of us on the commission saw, that the Supreme Court itself has become so out of step with where it should be, where the law should be, and because of the whole structure of the court, because of the lifetime appointments, that there is an iron grip on the direction of our law, that as we go forward, and as potentially with Roe v. Wade all but eliminated cutbacks on voting rights, and expansion of the ability of corporations to flood campaigns with money, and I could go on the litany of liberal complaints about the court, but I think there were a number of people who came to believe that things are so dire that unless you change the actual personnel of the court, as opposed to reforming the process of tenure, that it wasn't actually speaking to the crisis of the moment. So expanding the court, especially after the Merrick Garland situation, where I think often described as a stolen seat, there is just I think it's not the reform that will address the problems that exist in the moment.
Is there any kind of reform that would address the lingering concern and controversy over the Supreme Court stepping into what might have been considered state action in the Bush presidency being approved by a Supreme Court ruling when the controversy in Florida came up? Is that a reform that needs to be addressed, or is that just the way the court is composed, whether it's conservative or liberal? I personally have never reconciled how the court got away with doing what they did. Michael?
Mike,
Yeah,
Mike, you want to take that one?
Yeah, I would like to take that one, actually, because it goes more to the point of what I think is wrong with the court. My view of the court is on this point quite different from Caroline's. I think that the current court, it does some things that people on the left don't like, and earlier we had a court that did some things that people on the right don't like. And so there's always going to be some side that's unhappy with what the court's doing. And so I think that expanding the size of the court in response to something like that is a bad idea, because it has the perception and perhaps really the reality of just trying to make a political influence on the court. It's certainly not the kind of thing that is going to dial the temperature down about the court, as the commission points out in its report. Likely response to expanding the court by one side is going to be a expansion of the court by the other side once the other side gets in control of the levers of power. So while I don't think there's a particular unique size of the court that's the right size, a bigger court might be better. I think that changing the size of the court in response to political dislike of what the court is at the moment doing sets a very bad precedent. My concern about the court is not really about particular things that it's doing in the moment, but rather it's about the role of the court relative to the other branches of government. And this is why I think I ended up getting put on the group that I was put on to focus on those issues, because I think the court plays a much greater role than was ever envisioned by the founders, or that it played through most of American history. The court now is in charge of so many critical political, social, and moral issues. We find out what our government is going to do by seeing what the court is going to either allow it or require it to do. So Bush versus Gore is just an example of that. It's like, what we really want is to have elections decided by the people, and then in turn by local authorities. And we don't want the Supreme Court picking a president. But it's just, to me, it doesn't stand out in particular. It's just sort of an example of, there's all sorts of things that I think that we don't want being decided by a court, an unelected committee of 9 lawyers who have no particular expertise in most of the political, social, moral issues that they're addressing. Instead, we want to have those major decisions decided by the democratically elected branches. And so I think that the power of the court has gotten somewhat out of whack. The question is, what can you do about it? And that's why initially I was attracted, not so much to term limits, which I don't think would actually address that, but to some kind of reform that would reduce the power of the court generally, for example, to require a supermajority rule. And that's one thing the commission looked at, but it's also another thing that the commission decided once it looked at, that, wow, the details of the implementation of that are extremely difficult, complex, and hard to manage. But to go back to your question about specifically about Bush versus Gore, I just think that's an illustration of the court has more power in our system than the Constitution intended. I just don't know what to do about it.
Can I just say that I think Mike and I here are absolutely 100% aligned in terms of the analysis of the problem, and that maybe it's where we come to the solutions. But I agree. I mean, I think the court has definitely, it has an outsized role, and that's why I was also very attracted to this particular subject area of the commission, the kind of court's role in the constitutional system. Now, I would just say one thing, just to maybe slightly push back on you about the kind of, we like it now and then we don't like it later, and we can't just, I actually would just say that the Warren Court was a long time ago, and probably a lot of people who are participating in this webinar might not have even been born when the Warren Court, I was barely, and so, and I know Belinda probably wasn't at all, or either of you. So, so the Warren Court is along, and the court since then has been moving on a very steady rightward trajectory, and in the last couple of years, running in a rightward trajectory. So I would just say that I think, I don't think it's quite, we bat it back and forth that way, that it's generally been in one direction.
Now, the court has recently agreed to take on a case involving Harvard admissions policies and the policies of the University of North Carolina. And the question for you all is, do you see the court being interested in those cases, putting affirmative action at risk? Michael?
Yes, I absolutely do think so. I think that's why they're taking those cases. I think they're going to take another look at the Grutter case that allowed affirmative action in higher education admissions. And well, it's sort of like my answer with respect to Roe versus Wade. I'm kind of doubtful that they will use the O word and overrule that case. I think they're going to put some very sharp limitations on the ability to use race as a factor in admissions. And I think that is where that case is going. And I wouldn't be surprised at all to see some significant limits.
Caroline, do you agree? And if you do, what are the limitations you see this court imposing as a result of those two cases?
Well, I mean, I agree with Mike that I think they take these cases with a purpose in mind. And I think a number of the justices have signaled over time that they don't like the precedents. And so, the idea that diversity is kind of a possible reason that you can take race into account as one factor. Hard for me to really imagine how much more limited it could be. I mean, if you can't consider race at all as a factor, if diversity is not a justification for any kind of admissions policy, I'm not sure what you're left with. I mean, it really is hard for me. I'm sure they're thinking through, I'm sure they're probably the briefs will start giving them some kinds of alternative approaches. You have the Texas top 10, approach that didn't work out too well. So, I'm not sure what is left apart from, perhaps geographic. Maybe they can start looking at urban rural distinctions. I'm really just not sure. It's a puzzle.
Does the fact that the plaintiffs are from a minority group, the Asian community, how does that play into the risk that affirmative action is running with this particular court on these cases?
Oh, I think that plays into it enormously. I think you're absolutely right to put your finger on that. I think that this case was brought by some smart lawyers who wanted some sympathetic plaintiffs that would. I'm not saying it's a negative way. Actually, I'm saying an extremely positive way. It's good lawyering. You get some plaintiffs so that the ruling ends up being not that this is one more thing in favor of white people, but you make it a ruling for minorities, in a sense, and I think that gives the justices a lot of cover, and therefore makes it a much more likely scenario that some significant cutbacks will occur, because I think when the justices feel that they have some cover, that they're more likely to extend themselves. So absolutely, I think that is. I want to say real quickly that to me, I think you can tie this case, the affirmative action case, to your comment about Bush versus Gore and the discussion then we had about the court playing an outsized role in the moral and political aspects of the country. I personally think that it's very troublesome to take race into account in college admissions or in other similar decisions. But I don't want that decision to be made by an unelected committee of 9 lawyers or 5 lawyers, as the case may be. I think that's a decision that ought to be hashed out in the political process, and with respect to higher education, with the higher education administrators who look at these things very closely and know what the impact of different policies are on their student body. So I think it's disappointing, although in our current situation inevitable, that the final thumbs up or thumbs down on this policy is going to be made at the Supreme Court level. And they may come out the way I'd kind of like them to come out, but that doesn't mean I want the decision being made at that level.
Caroline, are you also troubled by having race be a factor in admissions for universities and colleges?
No, I'm not. I think that as one of many factors in the way that it's been considered for so long is an important part. We see what happened in California after the proposition was passed that limited any consideration of race, and the decimation of the minority population in higher education in California, I think was very problematic. That being said, I think it's important to devise policies that are very thoughtful, careful about how that's done. It seems to me that the policies that are being considered have been crafted that way. Especially when it seems that legacies, that's a perfectly fine thing to consider, is whether somebody's parents went to a university before. That clearly skews heavily white and wealthy, and yet that is a continuing factor that universities continue to look at. So if we were kind of analyzing what was really putting the thumb on the scale of in terms of race, that would probably be a much bigger factor than anything else. So I think it's probably, I would just say that it's interesting, and Mike, you both were just talking about sort of the background of this case, but the lawyer who brought it, Blum, has been behind a lot of the cases attacking affirmative action. This is his day job. He's been bringing this case for a long time. He now has the court that he wanted. And so this is going to be his moment.
Well, we could spend a lot of time on the difference between bias and racism and the role that it plays in admissions, but I can't help noticing that from the time I was in law school till now, the majority of law school students are women. That wasn't the case 30 years ago. And I think that's the direct result of bias, not racism. The doors weren't open because women weren't considered, worthy of the opportunity to excel in those institutions. Well, that's gone completely out the window. I don't think gender has anything to do with college admissions at this point. Maybe I'm wrong, but the impression is it has nothing to do with it. And hopefully we'll reach the point where race has nothing to do with it. But until then, affirmative action, is still at play. This many years after Bakke, we're still talking about it. I'm from the Bakke generation, so I remember well what those battles were all about. But let's switch gears. Let's go to something that I think is just as much on the mind of most Americans. The impression, the statistics may bear it out, maybe they don't, but the impression is that there's never been more gun violence in the United States than there is right now. You have mass shootings. You have an active shooter drama played out almost on a weekly basis across the country. And yet we don't seem to be able to get our head around the idea that gun control might be something that we should be dealing with, because there is a very strong, maybe not as strong as before, but a very strong NRA lobby that has prevented gun control. What role should the Supreme Court play in addressing gun violence across the United States?
It's a great question. I think maybe I agree with Mike here. Maybe we'll see where we come out. But I think the problem I think we really face is one of legislative cowardice more than, the Supreme Court, the Heller decision, subsequent decisions. We've seen certainly the ability for greater access to guns, but how much Congress could really actually do a fair amount if they could pass legislation and state legislation. I know the city of San Jose is just moving forward with the requirement of liability insurance for gun owners. And of course, the NRA is challenging that, or Gun Owners of America, or one of those other groups, and they'll be in the courtroom soon over that. But I think a lot of the problem here. The courts certainly, in my perspective, a problem, because I disagree with those decisions in Heller and McDonald. But apart from that, I think even where the areas where Congress could have passed, after the so many tragedies that we've had when children are being gunned down, and they can't pass what seems to be, generally, even with the Supreme Court, constitutional types of requirements, additional background checks and so forth, and perhaps, reducing access to certain kinds of high capacity assault weapons, or, another controlling ghost guns, for example. There might be, things that, and so I guess I would say, yes, but I think the real bigger problem here is that we have a super powerful lobbying force that seems to be able to trump the political will of our elected branches, even though the vast majority, some 90% of the American public want some kind of reasonable gun control. And that includes gun owners.
Michael?
Well, I guess I might quarrel a little with the premise of your question at the outset, because in California we have actually quite strict gun control, and it doesn't seem to have done us a whole lot of good in terms of getting gun violence down. So whether there's a connection between those 2 points, I think is I would say not proved in an event, and it seems to me that perhaps a better approach to getting gun violence down would be to have stricter enforcement of existing laws. But in California, we seem to be moving away from stricter enforcement of criminal laws and into more leniency. So I think that there are things that could be done that are not, that the Supreme Court is not standing in the way of. And I think that I certainly share Caroline's view that legislatures should be doing more, although what that more they should be doing, I think that is open to debate. On the question of the role of the courts, I think that, again, the court should do as much as it can consistent with the Constitution to let important decisions like this be resolved at the at the level of the political branches, whether that's at the federal government or at the state level, where I think it's probably more effective. I do think that it's although I'm in favor of the court playing a less active role, I do think that nonetheless, we are a constitutional democracy. We have a constitution, and the Supreme Court has to enforce the Constitution. And we do have a Second Amendment that says there's a right to bear arms. That has to mean something, although I think that it doesn't have to mean that the Supreme Court has the final word on every single measure of gun control that one could have. So I think that what I would like to see out of the Supreme Court on the gun control point is, again, modesty, which I think has been lacking in the courts, not just the current court, but in the modern court, really throughout my lifetime of the court, thinking that it can do better than the political branches in deciding what's the right approach. So I know that I'm repeating a bit of a refrain here, but I think that so many of these questions about, oh, the court is doing things that I don't like, very often come down to the court is acting beyond its constitutional role.
Well, Michael, you bring up a couple of points by mentioning the Second Amendment, and I don't want to get into the weeds because it's probably outside the scope of your charge, you and Caroline, but
all of this is outside of the scope of our charge, Your Honor, and we're happy to go there.
Good. I personally don't see how the Second Amendment makes it okay for a 16-year-old to stroll down the middle of the street with an assault rifle, as in a recent case that we just saw on a national level. It just, I find it difficult to reconcile how that's okay, Second Amendment or otherwise, or how a young person can walk into a Walmart in Texas and kill a couple of dozen people that he thinks don't belong in this country. We can get all the way back to, is it Sandy Hook, where all these first graders were killed? I mean, what has to happen before we do something on a national level? And if not the Supreme Court, then who? Because Michael, you say that, you know, this has to be a matter of enforcing our local laws. California could do a better job. There's states that allow open carry. And there's states that maybe are better at regulating, but there's no uniform way of addressing gun violence. And maybe that's what I'm reaching out for, is an answer from you very learned folks as to whether that's something the Supreme Court can take on. Caroline?
Oh, go ahead.
Well, you know, I think I am in absolute 100% agreement with you that one of the greatest tragedies in the United States is our inability to deal with this problem. I don't think having a gun is an essential element of liberty. I really don't. In fact, it's the opposite. I think there are plenty of free countries around the world that have very strong restrictions on access to guns. And if you look at their rate of violence, you'll see that is a corresponding much less violence, much less homicide. You know, it's just a lot. It's hard to go and kill a lot of people with a knife. It just is. That being said, I still don't think, though, that the court's not a place for a regulatory regime. And I think even under Heller and McDonald, there is a great scope for regulation. And Justice Scalia in the Heller decision, you know, I think subsequently talked about, you know, kind of reasonable types of approaches that, you know, I think, you know, the question in that case was, you know, can you have a personal gun in your home for protection? And that is very different from open carry. That's very different from, you know, a handgun is not some kind of assault weapon. And so I think it's where you start getting into those, again, I disagree with that decision. I do think there can be, you know, should have to, you know, permitting requirements, background checks, but also restrictions on types of guns, no handguns, but that's, you know, water under the bridge at this point. But I do think that all those other things, mental health checks, requirements for training. I mean, you know, to think about what we ask for people before they can drive a car, and not to expect at least that level of, you know, we have to get a driver's license, we have to take a test, you have to study, you have to register your car, If you do something wrong, you get pulled over by the cops. You can lose your license. So, I mean, we have that, and at least so far as I know, people aren't contesting that regime. Of course, there's no car right in the Constitution. But, I think if you also, there are a lot of people contest the reading of the Second Amendment that was made in Heller, sort of striking out the whole first part of it, which is about a well-regulated militia, and saying that, oh, that's just surplusage. I don't know where the textualists can just say that a section of the Constitution is just meaningless and let's just ignore it. That seems to be the only one area that I can think of. But that all being said, and I'm on a rant because I think, like you, Judge, this is a rather passionate kind of topic. But I do still think that legislatures can do a lot more. And Mike's also right. There should be more enforcement. That we have, certainly the porousness of state borders is a problem. And that no matter what California does, guns can get brought across the border. But there are federal regulations that could be developed and federal regulations that could be enforced.
Michael, you were about to respond when I turned to Carolyn on this last question. What were you going to say?
Well, 2 points in response to what you said. I think, first of all, none of the incidents that you mentioned or anything like them involved someone exercising a constitutional right that had been exercised that had been established by the Supreme Court. So it's not at all clear to me that the Supreme Court, that the responsibility for the gun violence that we have can be laid to the Supreme Court. Now, the Supreme Court has a very important decision in front of it this year about public carry, and we'll see where they come out with on that.
That's why I brought it up.
But the things that that you were talking about were not things that are protected by the current Supreme Court doctrine. The possession of the guns in those cases, depending on the cases, may or may not have been legal. If they were not legal, then that is a question of enforcement, not a question of the need for more laws. And if there were legal, this is the second thing I was going to say, is that we have a federal system, meaning that we have significant policy making at the state and local level. And we do that because in one significant reason we do that is because we're a big country and we have a range of views about things. And we have one view about guns in California, and there's a different view of guns in Texas. And so the way the federal system tries to accommodate that is, instead of having a one size fits all, then we have different laws in Texas than we do in California. And I think that's a great approach. And if the problems in Texas stem, for example, don't mean to be picking on Texas, but if the problems in Texas stem from the attitude towards guns and the laws that are then reflected by the legislature in response to those attitudes by the people, that's the price they pay. And in our federal system, that's the way it ought to work, is that different states make different choices.
Well,
and let me append, of course, because that's where I'm going, is I would like to see the Supreme Court leave that in place as much as it can.
okay. Now, in your executive summary, trying to get you back into the four corners of your report, you say, first, the report should include an account of contemporary commentary debate about the role and operation of the Supreme Court in our constitutional system and about the functioning of the constitutional process. What does that mean, Caroline?
Well, I think that really goes exactly to the topic that Mike and I we dug into, which is, the power of the court and how it relates to the other branches. And as Mike has said so eloquently, that the Supreme Court is stepping in too far, that it is exercising powers that really should be legislative. So that was the particular area we looked at, is how do you react to that, as opposed to reacting to the personnel court expansion idea, as opposed to reacting to the length of time they serve, the term limits proposal, as opposed to reacting to ethics questions like disclosure of and recusal, or cameras in the classroom, cameras in the courtroom? And all of those questions, this was really directed exactly to the question of, is the court too powerful and what do you do about it? And so that was where what that means. And then, we examined particular reforms that have been proposed in that area, and there are others, but our charge was really to look at the ones that are under most debate. And even this is not an area that has gotten a lot of attention in the reform movements. Periodically, when there is, say when the Warren Court was issuing certain decisions that were objected to because of issues around law enforcement or race, there were people proposing to strip the court of certain powers and jurisdiction over certain cases, or when the flag burning cases were coming up, to take away flag burning. And then the same thing has happened on the left, where efforts to strip the court of certain matters can be raised in response. So those were what we were dealing with. And that's essentially its role in the constitutional structure. We talk about separation of powers. There's also checks and balances, and it's sort of, you imagine, although, justice's scale only has two parts to it, but imagine, our branches are three, how much weight do they each have? And I think, the first Article 1 of the Constitution is all about Congress. It's a whole lot longer than Article 3, which deals with the courts. And, the essence of that is, Congress should be, it's the first part of the Constitution. Does that make it the most important? In some ways, yes. I mean, we're supposed to be a democracy. That's supposed to be where the action is, not in the court.
Now, you touched on a topic right now by mentioning cameras in the courtroom. Well, there's two periods of time where that came up. One is prior to the current pandemic, and the second is now that COVID is raging for 2 years straight, and many courts that are in operation are doing it remotely. Michael, what is your feeling about cameras in the courtroom, particularly in the Supreme Court?
I don't have a real strong feeling about that. I think some courts do have cameras, and as I understand it, and it doesn't cause a problem. I do wonder a little if it would cause a problem at the Supreme Court, because they're more obsessed with the Supreme Court than they have with lower courts. I think there's a little bit of a danger that pictures can be taken out of context, can be turned into memes, and people may lose an understanding of what's going on in the court. They may focus too narrowly on some particular gesture by some justice. I don't really like being on camera all the time, although now I am in my teaching. But I don't have the kind of quasi-celebrity status that Supreme Court justices do. So I think there might be a little unease on that. On the other hand, I think that we could probably get used to it. So I don't have a real strong feeling about it, but as with a lot of the things sort of in the back end of that report, or the sort of incidental reforms, I don't think you got to make much difference one way or the other. So I don't work too hard at coming up with an opinion on it.
Well, Caroline, you brought up the issue of cameras in the courtroom. It causes me to believe that there was at least some discussion among the commissioners about that topic. What was that discussion like? What was it about?
Well, it was, this was not contentious, probably. It wasn't that there was all agreement, but it was definitely not as heated, to the extent that we had, I wouldn't say we didn't really have heated debates, but there was certainly disagreement. In this area, I think it was more, the question is it disruptive in some way? The justices seem reluctant to have cameras. I think most people were with Mike that it's sort of, probably a good idea. It's worth a lot of attention. There are a lot of bigger fish to fry. I would say that streaming audio, I think that's super popular. I think that's really helpful. If they would continue that, I think that would go a long way towards giving people access to the arguments in real time. That would be meaningful without, the justices have to be uncomfortable about their face appearing on the nightly news, or in some tweet somewhere. Although that's still going to happen, right? You can still pick a justice's face and put it in a tweet, and it's, you have the same outcome, whether they're really you're seeing live stream from the Supreme Court or not.
Now, you mentioned that the topic of cameras in the courtroom was not among the most heated debates that you all had to discuss. Michael, what was the most heated topic debate that you found yourself involved with as a commissioner?
Yeah, I think the biggest debate within the commission was on the court expansion. Because I think that was the area where people felt the most strongly on both sides. There were some people who were very, very strongly in favor of court expansion, and after the commission submitted its report, which they thought was too watered down, some people wrote some very strongly worded editorials about that. Some members of the commission. But there were also then some people felt very strongly on the other side that court expansion, at least in the current political moment, would be a terrible mistake, and they voiced very strong opinions on that within the commission. And then they wrote some op-eds after the commission completed its work, taking that view. So you can kind of see the back and forth if you look these publications up, and you'll see people taking some very strong stance. It was all very cordial, and I think that was a real testament to the composition of the commission and to the leadership we had of the commission. Caroline, I don't think we've said enough about the leadership of our commission at this point, and I think we should, because I think that our co-chairs were outstanding appointments, and they kept us on target, and they kept us getting our job done, kept us focused, and so we debated these things, but in a cordial and reasoned way, and I think it was a very successful and useful process.
So, Caroline, would you like to take this opportunity to enlighten us about the commission leadership and what we need to know about that?
Well, I agree with Mike 100%. I mean, it was a very collegial undertaking. It was kind of say you could disagree without being disagreeable. It was definitely one of those kinds of situations. People were really very respectful of each other. Bob Bauer and Christina Rodriguez, who were the co-chairs, really just did an incredible job. I have to say, I've known Bob and Christina for a number of years, Bob particularly for many, many years, and Christina for more recently. But Kate Andreas, who was also the secretary for the commission, so basically number 3, 2 co-chairs, and then she was in the leadership as well. They just did an amazing job. They did keep us in line and keep us going to meet our deadlines. They also did a tremendous amount of work, because the synthesis of the report was an incredibly big job, and they read our drafts and they critiqued them and they gave us feedback, and it helps that they're all brilliant, but it was really substantive, thoughtful, respectful, and I think, as I said earlier, I think the report that we produced is really substantial and an incredible resource for people who are interested in these questions. It's not going to give them the answer, but they can analyze the arguments and hopefully come out in a place that they think is right. And I do think it'll be useful for people who are engaged in the reform debate to really be grounded in the main legal arguments and an analysis of the kind of the consequences and upsides of any particular proposal.
Now, you, in your report, the collective, you in your report addressed in chapter 5, among other things, judicial ethics. Michael, what was the purpose and what was the outcome of the analysis that you and the commissioners came up with? For those of us who have not read the entire report, where are we on judicial ethics in the Supreme Court?
Yeah, I have to admit that this is another area that I found to be not terribly important compared to the other topics that we were taking up.
That's
Not that ethics.
that's probably why it's at the end of your report, but go ahead.
Well, I don't know. I didn't choose where it would go. I think now, not to say that ethics aren't important. Ethics, of course, are terribly important. And one of the oddities of the Supreme Court, as the commission report points out, is that while there is a code of ethics for federal judges, it doesn't apply to the Supreme Court. It only applies to lower federal court judges. I have no idea why that's true. And it doesn't seem like that makes a lot of sense. And the commission kind of points that out and says maybe that ought to be fixed. And it's not obvious to me why that shouldn't be fixed, although the Supreme Court, Chief Justice Roberts just most recently had a recent announcement saying that he didn't see a problem and he didn't think it ought to be fixed and Congress should stay out. But I'm not sure why there shouldn't be a code of ethics. On the other hand, I don't really think that the problem we face is that we have an unethical Supreme Court. I'm not really aware of any significant ethical issues involving the Supreme Court. I think that there are some issues with the Supreme Court. But to me, the ethics are not them. I think all of the justices are extremely upright, outstanding, and take their jobs extremely seriously, and they're the people of the utmost integrity. So I really, and I'm not just saying this to try to be nice to them in case I have a case in front of them. I really do believe that of every single one of them. And the commission report doesn't give any reason to think otherwise, I don't think. And so I don't really understand, I guess, the issue of the significance of the issue as a practical matter. Although I think in the abstract, I do think that ethics are terribly important. And I don't understand why there isn't sort of a parallelism between the ethical obligations of lower federal courts and the Supreme Court. But again, I don't think that lack of ethics is the problem we face with the court.
Well, you touched on the very reason I asked the question, which is why don't the programs or ethics that apply to the lower courts, why don't they apply to the Supreme Court? Do you have a thought on that, Caroline?
Wait, sorry, I didn't understand your question.
Michael points out that there is a code of ethics.
Why it doesn't apply to
applies to the lower federal courts.
I've never understood that. And there's an argument that gets made that there's a separation of powers question, and that doesn't make any sense to me either. Because if it can apply to the lower courts, I don't really see that there's a different separation of powers question here. It's the judicial branch, it's the legislative branch. If it was, so I really don't understand. I think, from what I understand that, the sort of, that there was a debate in Congress in the past about applying to the Supreme Court, and they talked themselves out of it and decided it wasn't necessary, and so didn't do it. Now, I think I agree with Mike, though, that, it's not like there's a glaring problem, most likely. I think it would be a good thing to do, because I think to the extent that we worry about the court losing legitimacy, it should be treated justices should be treated the same in terms of their kind of financial disclosures and requirements for recusals and other aspects of ethics. The thing, though, that I think is perhaps more troubling overall with the judiciary is the fact that there has been seemingly little effort to, well, perhaps not little effort, but few results to deal with the issue of sexual harassment or harassment of law clerks and staff. And Chief Justice speaks to this as well in the same report. It sort of says, stay out. We're making great progress, and yet I don't think we've seen any of that. And I think you here in Southern California, have seen some of that. And we don't need to name any names, but let's just say really problematic. And there aren't the kinds of rules, there aren't the kind of systems that could provide mechanisms for law clerks, for staff to have an avenue. And so I'd just say the Ninth Circuit has now taken on and has instituted some of the best reforms in this area. But it's really a circuit by circuit, courthouse by courthouse approach. And it would be nice if the Chief Justice would step up a little more, or Congress might.
Now, speaking from the trenches of a Superior Court trial judge, I can tell you that it is impressed upon us, and that's putting it nicely, how important conflicts of interest are, and the mere appearance of a conflict of interest can be to a bench officer. One would think that the same would apply to the Supreme Court, yet in the case of Clarence Thomas, his wife Gia is openly espousing very conservative views in the era of transparency, which is also part of your report. How does that play when the spouse of a Supreme Court justice is out in public, out front and center with such very, very controversial views and the appearance of bias that might result?
I know we're talking about Ginny Thomas, so I will just say that name, but
I said the name. I said the name. That's what I said.
Yeah, so that's, I think, it's certainly something that gives me a great deal of pause, and maybe I should, mention that I think one of the questions that came up in the Q&A that, I think you're referring to is, the issue of appearances. It's not just necessarily an actual conflict of interest. And I think this was, something that is very uncomfortable for people to see. To what extent should there be a rule where the spouse of a justice, or maybe the child of a justice, their activities should mean that they can't rule? I think, I wish he would have recused or will recuse or, will consider these things, but I guess I'm not quite sure yet that there should be a rule, because I'm not sure how, how that would be devised, at what level that would be appropriate to start restricting spousal or children's activities.
Well, I'm not suggesting that it constituted an actual conflict of interest for Justice Thomas, but rather, again, circling back to the things that are impressed upon bench officers, the mere appearance of bias or a conflict is cautioned as something that you must avoid at all costs. Michael, any thoughts on that?
I think this is a tough issue because we have so many two career spouses, two career marriages now. And the result of that is, and it's very common that someone in the legal profession, that their spouse is also in the legal profession. And the result is that it is very common. And you mentioned Justice Thomas, but this is a very common issue across all sorts of judges at all sorts of levels. And it also has to do with, it's partly you have people who are, politically active, but you also have people who are spouses who are lawyers, who then work for law firms that appear in front of the court. And so the legal network is so big, and the possibility of this kind of conflict is just extremely common. So what do you do about it? Well, I think you could have a rule that that people have to recuse, but that's going to be an enormous number of recusals. And it's going to be extremely hard on judges and spouses of judges who are where the spouse is politically or legally active. And we just have to think about, is that a rule that we want to have or not? Right now, we don't have a rule that this is an issue. And I think what I'd like to see is to have it clearly said that this is okay or not okay. I think the problem now is we have selective outrage. We have people who are extremely upset about the Thomases, but not upset about similar situations of more left-leaning judges, such as, for example, Judge Reinhardt on the Ninth Circuit, whose wife was active in the ACLU, which of course had many cases in front of the Ninth Circuit. And of course, people on the right were very upset about that and caused all sorts of trouble about that.
I'm trying to keep you in the four corners of the Supreme Court.
Well, but I don't think you can on this issue. Because it's an issue, and as you started out saying, it's an issue for you as the lower court judge, and it's an issue for all lower court judges. And there's no reason that you would have a rule for the Supreme Court that you wouldn't have for other lower courts on this point. And so,
Or
uh,
vice versa.
or vice
You
versa.
know,
I agree.
If I could just, I'd have to say I disagree on that. I'm not, again, I said I'm not quite sure yet. This is one I'm still, mulling over, that there should be a rule. But I think the Supreme Court's different. I mean, there's no appealing from the Supreme Court. So, if Judge Reinhardt was, more inclined to rule in favor of the ACLU, that's problematic, certainly, if that didn't have something to do with his overall orientation anyway.
I just want to say real quickly, I don't for a second think that Judge Reinhardt was more inclined to rule for the ACLU because his wife worked for the ACLU. I didn't mean to make that implication at all, although some people did, but I just think that's wrong.
Right. Well, so I just want to say that, I'm not necessarily disagreeing with the substance of the argument. I just do think that we could make, if we were making a rule, that there would be more of an argument in the case of the Supreme Court than there would be for the lower courts, just because of the nature of the rulings, that if there's any question about whether there's been bias in a ruling because of a spouse's engagement. Now, that being said, again, I think, when you have the Thomases, it's probably wouldn't be that surprising to have Justice Thomas be inclined to rule one way or another, regardless of whether Ginny Thomas was actually directly involved in that group or not.
So let me interrupt myself, because I've got a whole menu of questions that I want to ask you all. But I also want to make sure that if we have any questions from the folks who are on the webinar with us, that we at least have a chance to ask you a couple of them on their behalf. Belinda, do you have any of the questions that have been submitted?
We do have a couple. One was a follow-up question about expanding the court. And somebody makes a good technical point, which is that one inevitable effect of expanding the court is the increased amount of required reading each case would involve, because the justices circulate views before publishing decisions. So was there any discussion that an expansion of the court might lead to a further reduction in the number of cases that the Supreme Court could hear annually?
Well, I don't think so. And in part, perhaps because the Supreme Court is hearing a historically low number of cases. So it may not be a lot of sympathy in some sense for them, that they'd have a few more documents to look at, because they used to handle, at the end of the 19th century, if you read the great historical section in our report, you'll see that they were handling thousands of cases before a major court reform legislation went through. The fact that they handle, 70 now is, I think it just didn't really get a lot of, if any, attention. I don't know, Mike, am I wrong on that?
There was a little discussion about whether it would increase or decrease efficiency to have more justices. But yeah, I think the general feeling was that there's probably some excess capacity at the Supreme Court right now, and so it's something that causes them a little bit more work is not going to be a major factor.
Belinda, any other questions?
I think most of the others are kind of beyond the scope of what you all were talking about. So if you have more questions about the report, I think it makes sense to discuss those.
Well, I want to make sure first, Caroline, is there anything about your report that we haven't addressed so far in the last hour and a half that you want to make sure we hear about?
No, I was just, in the back of my mind wondering if that was Carlos Santana on your wall, but that's not part of our report. You'll have to tell me separately. I think we've covered a lot of it.
Yes, that is Carlos.
Okay, excellent. I'm a big fan. Let me just say, I think that one of the really worthwhile parts of the whole report is valuable, but I think if people skip the beginning and go right to the kind of recommended reforms and don't read the history, I think it's a really valuable discussion. I learned a lot from it. There were some incredibly well-known, well-respected legal historians who were part of that and brought their intellect to drafting. And I think it really does help illuminate a lot of the other questions. And you also realize that, we've been around this block before, that these debates are not new. They've been here since the beginning, the absolute founding of this country and the adoption of the Constitution. So I think that's also a good perspective to have, that court reforms of various kinds, certainly court expansion, which has happened a number of times, and reduction have been part of our political debate.
Well, I personally found the historical perspective of your report absolutely fascinating, but I didn't want to go there because that's something that we can all read and better understand by the way you presented it in the report. I wanted to touch, and hopefully we have touched on the subjects that we would all love to hear about if we had another chance to talk with you all. Michael, anything that we did not cover that you want to make sure we hear about?
I think that we've covered all the major points, and I agree with Caroline about the historical section, that there might be a tendency just sort of to flip through that and to get to the real reforms. But I think the history is very valuable to see what is sort of what came before. Maybe one thing I would mention is that I believe that there was sort of, in the nature of a concurring opinion, added to the report. It's not part of the report itself, but it's available on the website, and then it became an op-ed that was written by two very distinguished former judges who were on the commission, Judge Griffith and Judge Levy. And they had I think, a somewhat different perspective on sort of the role of courts being judges, and the importance of courts and the value of courts to the rule of law system, or at least they wanted to sort of make a statement about that, that wasn't entirely within the scope of the commission, but they felt that the commission was sort of not as saying as much about that as they should, and so I thought that it was well put. And I encourage people to look at what the two judges have to say, because the most of the people on the commission were law professors or practitioners, and I think the judges had their own unique perspective that was very valuable.
I would say there was another judge, Judge Nancy Gertner, was also on the commission, and she also wrote a piece with Larry Tribe for the Washington Post that maybe in a somewhat different place from the other judges, but let's not forget, those weren't the only judges on the commission.
So I've got about 60 seconds to ask one unfair question. I'm allowed one unfair question. Caroline, who do you think Biden's going to nominate to replace Breyer?
Look, I only know what I read in the newspaper, so I think it's probably one of the three that's been named, and I think they're all amazing, so I'd be eager to see any one of them.
Michael?
Or others.
I have no particular insight on that point. So I think I will not comment, because it would be just pure speculation on my part.
Okay, fair enough. I can't thank you both enough. Even have trouble expressing what a thrill it was to be able to speak to the both of you about the different subjects contained in your report and outside the four corners of your report. It's not often that we meet folks who have the insight that you all have as commissioners on a presidential commission. So thank you so much for being here, for sharing your thoughts, your views, your opinions. I personally think that you have put on one of the best panel discussions that certainly I've ever been a part of. And I think it's fair enough to tell you that thank you. We really appreciate it very much. Belinda, anything further?
No, thank you all so much. This was just a great discussion. We all really appreciate your time.
Thank you. It was a pleasure.
Yeah, thank you for having us, and Judge, thanks for your great questions.
Absolutely.
It wasn't a question. I was taking your depositions. Bye,
Wish
folks.
I was there in Beverly Hills, though. That's my.
What's that?
I said the only thing that I wish was better was that we were actually together, and it was in Beverly Hills and not here in 10-degree Washington, D.C.
Ooh, ouch.
Yeah.
Sorry. Okay, goodbye, everyone.
Right.